Hi, I'm Kasturi Patu, Member of Parliament for Batu Kawan. These days, as more people spend more time online, youths and children are exposed to cyberbullies. They become victims and they suffer in silence. Malaysia ranks number 2 in Asia for cyberbullying, according to international polls. And according to UNICEF, 1 in 5 children don't go to school as a victim of cyberbullying. The question is, are the laws in Malaysia enough? Are they adequate to nab these predators and cyberbullies who harass, torment and bully people online? The answer is no. It is time we pool our resources, band together to remind the government of its obligation to be protectors and defenders of the rights of children, of the rights of youths, men and women, of users of the internet. We need a new standalone bill to protect everyone online, to protect you and to protect me. The time is now for the government to table a new act on anti-cyberbullying in Malaysia. Thank you.
Hello everyone, this is Dr. Rahim. Since COVID-19 hits the global, many of us started to use cyberspace and cyber platforms to perform our daily works. This actually increases the risk for us to become the victim or target in cyberbullying. In fact, we have witnessed so many cyberbullying cases recently, and the trend are escalating day by day. What could be the possible factors for the perpetrators to do this so freely? Maybe the absence of specific and stand-alone cyberbullying law in Malaysia. And this is the high time for us to have cyberbullying specific and stand-alone cyberbullying act in Malaysia. And this could be a benchmark for many countries in the world. When we have such framework, when we have such legislation for cyberbullying, this will stop people from committing cyberbullying. In fact, from the criminological viewpoint, we can explain this using rational choice theory. When the punishment increases or when the risk for a person being caught is increases, that actually will stop one person, that will actually stop that person to commit any crime, including cyberbullying. Therefore, this is the high time for us to have a specific and stand-alone cyberbullying act laws in Malaysia, so that this could be a remedy to stop people from bullying others in cyber platforms. Thank you.
A 21-year-old young woman commits suicide by hanging herself. She was repeatedly insulted, humiliated, trolled, adverse comments made against her in social media. All because she had uploaded a TikTok video showing her dancing away with her male colleague. All in innocent fun. You could see the enjoyment, you could see the joy in her face as she was dancing with her friend. All this came to a tragic end due to the senseless, aggressive and downright disgusting behavior by netizens. A 20-year-old young man, an undergraduate at a university with a bright future in front of him, jumps off a building and ends his life because of nasty comments posted on Facebook, questioning his intelligence and his mental ability. A 31-year-old firefighter is found dead with a suicide note. Apparently, she was pushed to end her life due to derogatory and insulting comments about her, questioning her sexuality, her morality, posted in a forum allegedly by co-workers. Ladies and gentlemen, this is cyberbullying. This is an adverse and negative effect of cyberspace. Bullying has moved from the traditional platforms of schools, playgrounds, offices to cyberspace. And what makes it insidious and even worse is that an act of cyberbullying can become widespread just by a click of a mouse within the blink of an eye. In Malaysia, the situation is quite serious. Surveys conducted by organizations such as Comparitech and UNICEF have revealed that Malaysia ranks high in the list of countries that experience serious problems of cyberbullying. So what are we Malaysians doing about it? The research team of MMU decided that we should embark on a project to examine various ways in which cyberbullying can be stemmed. Let us be frank, it cannot be eradicated, but it can be stemmed. So we started looking at different avenues and we finally came to a conclusion that the legal solution or a legal solution is the best solution that we could use. We conducted surveys, we had meetings, roundtable discussions, and so on. And the overwhelming response was that yes, we do need an anti-cyberbullying law. As we carried on our research, we discovered two factors that were supporting our goal. The first factor was within our own national system. The government's national cybersecurity strategy, in particular Trust 2, is focusing on updating or creating laws to address emerging threats in cyberspace. Cyberbullying is one of them. So that was one factor that was very encouraging for us. The second factor is of international relevance. This is the United Nations Sustainable Development Goals. And we discovered that the nature of our project, the aims and the objectives matched several Sustainable Development Goals. In particular, Sustainable Development Goal number 3, which relates to good health and well-being. Sustainable Development Goal number 4, which relates to quality education. And Sustainable Development Goal number 16, which relates to peace, justice, and strong institutions. And I have no doubt whatsoever that if we had looked at other sustainable development goals, we would be able to fit in our work. Ladies and gentlemen, we cannot stress the importance of our project. This project applies to the whole country, and we are positive that the outcome of our work will have significant impact on Malaysians. Cyberbullying is a universal menace. Cyberbullying is a national menace, and we need to do something about this. And we are assured by the lofty ideals of our work, and we hope that the government will take our proposal into consideration and put in motion the process of establishing the anti-cyberbullying law that we are proposing. Thank you for your patience.
All right, so thank you everyone for your patience again, and thank you the team for the montage we shared just now. So without further ado, we'd like to kick off the session with a welcoming speech by Ms. Aisha binti Muyub, who is a consultant at the research team. I'll be passing the stage to you, Ms. Aisha.
Thank you. Welcome for all of you from abroad and within Malaysia to the 2022 International Symposium on Cyberbullying Issues and Challenges. Our heartfelt gratitude and appreciation to the MMU President, Datuk Dr. Mazliham bin Mohamad Suud, for his presence to officiate this international symposium. Thank you, Datuk. As a background, in 2020, Malaysia was ranked second in Asia for cyberbullying among youths, according to the recent United Nations Children's Fund report. Rapid growth in internet coverage and high usage of social media platforms have led to a spike in cyberbullying cases in the country. Cyberbullying can hurt victims psychologically, emotionally, socially, physically, and finally damage their behavior and attitude. In addition, cyberbullying contributes to deadly long-term effects on victims. Multimedia University has been given the task with the support from the Ministry of Communications and Multimedia Malaysia to assist in the establishment of a legislation on Anti-Cyberbullying Act. This standalone Anti-Cyberbullying Act will focus on the definition of the offences, types of the offences, the victim's right, punishment on the offenders, complaint mechanisms, role, and responsibility of the social media and internet service providers, and treatment and rehabilitation of the offenders on the basis of restorative justice. The theme of this symposium is cyberbullying and how do we manage the issues related by cyberbullying as it is now on the rise, especially with the advancement of technology and due to the COVID-19. We have experts from across the field who will share with us their thoughts, knowledge, and opinions. And I'm sure that you will have interesting and productive sessions. Please feel free to write down your questions in the chat box and channel it to any of the speakers. It is our sincere hope that with the outcome of the International Symposium, it will assist the MMU research team to formulate a list of possible issues and challenges in managing the cyberbullying cases for the purpose of drafting a draft legislation on anti-cyberbullying for Malaysia. Before I end, and on behalf of the project leader, Dr. Bama Siva Subramaniam, I would like to express our sincere appreciation to all of you who has generously joined us and make this event to a success, and especially to the team members of the MMU research team. We couldn't have done it without you. So with that, a very warm welcome to each and every one of you. Thank you, and over to you, Ben.
All right. Thank you, Ms. Aisha. So we would like to now welcome Yang Berbahagia Professor Dr. Mazliham Mohamad Suud, President of MMU, to this event. Thank you again for spending your time to grace this event despite your busy schedule. So ladies and gentlemen, now let's welcome President of Multimedia University, Professor Dr. Mazliham bin Mohamad Suud, to deliver the officiating remarks.
Thank you, Ben. Puan Nur Asha, Yub, invited speakers, panelists, distinguished guests, organizing committee participants who are joining us online from around the world. Ladies and gentlemen, Assalamualaikum warahmatullahi wabarakatuh, and good morning. It is an honor for me to welcome everyone to this International Symposium on Cyberbullying Issues and Challenges. On behalf of the organizing committee, I would like to extend my utmost gratitude to all participants for attending this significant event. I believe that this symposium is timely organized as studies and surveys have highlighted the increasing dangers that are posed by cyberbullying, not just in Malaysia, but in other parts of the world. It is vital for us to spread awareness of this worldwide problem and how to solve the issues. Ladies and gentlemen, in 2020, academics from MMU met the Minister of Communication and Multimedia to propose a solution in addressing the impact of cyberbullying cases on victims and their families in Malaysia. The minister gave his approval, and the MMU research team embarked on their journey to formulate and fine-tune the proposed solution, which is to establish a standalone law for cyberbullying in Malaysia. One of the mechanisms in achieving this solution is by organizing this symposium. This is indeed a great avenue for researchers and academicians worldwide to exchange views and share experiences on the topic of cyberbullying and its challenges. More insights and input could be gathered and measured for us to solve this worrying issue. Ladies and gentlemen, I would like to take this opportunity to thank the array of speakers for taking part in this event today. I note that they are both national and international speakers, renowned experts in their respective fields and in both academia and industry. The diverse range of speakers adds an interesting dimension to the symposium. Thus, participants will obtain knowledge from different aspects and different perspectives of cyberbullying. Allow me to welcome the speakers who are experts in their areas from various academic institutions, namely Professor Dr. Zahrutul Rushida Hinduan, the Dean and Psychologist from Faculty of Psychology, Universitas Pajajaran, Indonesia, Dr. Ika Rianti Purboningsih, Psychologist from the Faculty of Psychology, Pajajaran University, Assistant Professor Dr. Lata Subramaniam, Criminologist from Department of Criminology, University of Madras, Chennai, Tamil Nadu, India, Associate Professor Dr. Muhammad Rahim Kamaluddin, Criminologist from the Faculty of Social Science and Humanities, University Kebangsaan, Malaysia. And the cyberbullying has many angles to it, and its unique nature requires examinations of those angles, including that which would be elucidated by our honorable speakers. Besides speakers from academia, I also would like to welcome speakers from the industries. They are Mr. Brian Carey, the Chief Executive Officer of DatSafe New Zealand, Mr. Martin Cocker, the Online Safety Consultant of Online Safety Exchange from New Zealand, Ms. Ella Seri, Manager of International Engagement and Capacity Building, the Office of the E-Safety Commissioner in Australia. The three of them will give us insight into the working and experience of the alternative dispute resolution mechanism that have jurisdiction to hear and address cases of cyberbullying. The input from the speakers will definitely assist our MMU research team to propose a similar mechanism to the Malaysian government. It is a privilege for MMU to be entrusted with such an important task that would benefit Malaysian society and to be on the same path with the country's aspiration in becoming a mature digital nation, as well as achieving the United Nations Sustainable Development Goals. Let me once again thank our fantastic speakers for their time and valuable insight today. I wish everyone a fruitful day, and I'm sure that you will derive much to know and much to ponder. With the note and with the lafaz Bismillah Rahman Rahim, I hereby officiate the International Symposium on Cyberbullying Issues and Challenges. Thank you. Assalamualaikum warahmatullahi wabarakatuh.
All right. Okay, thank you, Professor Dr. Masliham, for officiating the International Symposium on Cyberbullying Issues and Challenges. We are very honored to have your presence despite your busy schedule. Now, before we kick off with another speech here, I'd like to play a short montage. Yeah. All right, thank you, everyone. So I would like to invite Dr. Bama Sivasubramaniam as a keynote speaker for the first session titled Understanding Cyberbullying from a Legal Context, Issues and Challenges. I'll be passing the stage to you now, Dr. Bama.
Thank you very much, Ben. Good morning, everyone. Honorable President Dato Professor Dr. Masliham Mohamad Sood, invited panelists and speakers, distinguished guests. Thank you for taking your time to attend our symposium today. It also shows us that the topic that we are discussing on, the topic that we are focusing on, is of interest to a lot of people, regardless of which disciplines you all come from. Before I go on into the main thrust or the main focus of my speech, I would like to share with you the background, how this research came about. Being a keynote speaker puts a heavy burden on someone, but the message that we want to deliver is far more important. So please be patient with me whilst I take some time from you to explain how it all came about. Those of you who saw the video earlier on, the video montage that we did, you would have known the background to this work. I would like to point out at this point that that video actually won the Gold Award at the Malaysian Technology Expo and the Outstanding Innovation Award. So again, it goes to show how important cyberbullying is. Right, let me share with you the background. In 2020, Malaysia was rocked by the suicide of a 20-year-old young woman. She had hung herself from the fan in her room. Investigations revealed that she took her own life because of unceasing harassment in social media due to a TikTok video she had posted of her dancing with a colleague. The mob mentality with pitchforks ended in her death. The sad fact was she did not know those who had pushed her off the cliff, so to speak. Another 20-year-old jumped off a high-story building due to constant haranguing by his classmates in Facebook, insulting his intelligence. The message he left for his parents was poignant and heart-wrenching. "Burn me to ashes," he said. "Release me by the sea. No tombstones, no funeral. Goodbye." Ladies and gentlemen, this is the dark side of internet. This is cyberbullying. It is axiomatic that the internet plays a significant role in our lives. It is its ubiquitous nature, the perceived anonymity that it allegedly promises, and the relatively ease of access that it offers, unfortunately, has negative aspects in that it can and is prone to abuse and misuse. One such negative aspect is cyberbullying. This is a worrisome phenomenon of the internet. The misconception that cyberspace is a wilderness without any laws or regulations has exacerbated this problem. As with cyber risks and cyber threats, cyberbullying is a universal disease. Cyberbullying can take many forms: harassment, stalking, defamatory comments, abusive emails, harmful gossip, doxing, trolling, hate speech, body shaming. These are just a few examples of cyberbullying. Unfortunately, the list is not exhaustive. Statistics show that Malaysia ranks high amongst countries where cyberbullying is concerned. In a recent survey on cyberbullying carried out by the United Nations Children's Fund, UNICEF, and the United Nations Special Representative of the Secretary General, it was discovered that 3 in every 10 Malaysians had been victims of cyberbullying that affected their education and social life. Complaints received by Cybersecurity Malaysia showed an increase in cyberbullying incidents between the years 2017 and 2020. Up to May 2021 alone, 119 complaints of cyberbullying were made to its helpline, Cyber 999. Ladies and gentlemen, the impact of cyberbullying is more insidious than the traditional offense of bullying. Studies have shown that cyberbullying could also lead to serious mental and emotional issues such as depression and anxiety and stress-related disorders. These are intangible illnesses which cannot be identified straight away. However, this is not uniquely a Malaysian problem though. It is a problem in the United States, it is a problem in Australia, New Zealand, in Hong Kong. Korea and Japan have had their fair share of suicide cases because of cyberbullying. In Korea, it was the suicide of 2 celebrities, very famous soap opera actresses, serial actresses. In other words, ladies and gentlemen, cyberbullying is a global social menace. We have surveys, we have studies. Where do we go from here? So it is in this landscape that the research team started doing our work. My research team members and I were concerned at this problem. It was the elephant in the room. Everyone knew it was there, but people did not know how to handle it. So we then formed a team to look into the need for the establishment of an anti-cyberbullying law. And before I go there, I want to take you to the background of our research. There are 2 areas that I want to talk about before I proceed to speak about our project in greater detail. The first one, both involves the obligations and the stance of Malaysia. Under the national radar, Malaysia has a robust approach to build a mature digital nation. To this end, the government and the respective government agencies have developed policies and strategies on cybersecurity. There are 2 policies and strategies that I want to talk about or give you an insight. The Malaysian National Security Policy was introduced in 2005. Its goal was and is to establish a secure, resilient, and self-reliant critical national information infrastructure. The vision, as was gleaned from that policy, was that the critical national information infrastructure will be secure, resilient, and self-reliant, infused with a culture of security. It will promote stability, social well-being, and wealth creation. As you can see, the main issue or the crux of this vision is to have a secure and resilient cyberspace, right? Thrust 2 of the policy was of particular interest. It covered legislative and regulatory framework, and it had three main aims: review and enhance Malaysia's cyber laws to address the dynamic nature of cybersecurity threats, establish progressive capacity building programs for national law enforcement agencies, ensure that all applicable local legislation is complementary to and in harmony with international laws, treaties, and conventions. The second national instrument that is of importance, and I would urge you to read up. You can find it in the internet. It is a very comprehensive and helpful document, and it is called the Malaysian Cybersecurity Strategy, MCCS, which is operative between 2020 to 2024. The vision of MCCS is to ensure that Malaysia's cyberspace is secured, trusted, and resilient, fostering economic prosperity and citizens' well-being. So what MCCS has done is to have its objectives placed under 5 strategic pillars. The pillar relating to law comes under pillar 2. As you probably would have known by now, my perspective is from the legal perspective. So pillar 2 focuses on the strengthening legislation framework and enforcement. The aims of this pillar, inter alia, includes enhancing Malaysia's cyber laws in addressing current and emerging threats. Ladies and gentlemen, it goes without saying that cyberbullying is one example of a malicious emerging threat. Secondly, under the international radar, Malaysia's obligations under international law will fall under the United Nations Sustainable Development Goals. Malaysia is very focused on implementing SDGs into our own national framework. In fact, our foreign minister, who has just released an announcement in Instagram emphasizing on the importance of Sustainable Development Goals. Cyberbullying, there are 17 goals, and cyberbullying falls at least under 3 or 4 of them. The main one, of course, is the SDG goal number 16, which is to promote peaceful and inclusive societies for sustainable development, provide access to justice for all, and build effective, accountable, and inclusive institutions at all levels. So cyberbullying could also fall under other goals, such as goal number 5 that talks about gender equality, and then goal number 4 that talks about education and so on. So this is our framework. This is the support or the background that we had when we started on this research journey. So the work of the research team of Multimedia University. What was our approach? Having identified that cyberbullying is really a serious problem, in other words, we basically snared the elephant in the room, we then decided that we need to have a well-balanced approach to how we are going to advise our government. The main aim of this research was to examine cyberbullying from legal perspective. It explored several issues that included addressing the lacuna in the existing acts of parliament, the lacuna being the gaps, and address them specifically in an independent and standalone legislation. The first point of observation is that there is no specific law in Malaysia that addresses cyberbullying. It was therefore necessary to examine this issue from 3 different angles. The angles were as follows. First, whether the existing laws are adequate. Second, if they are not, then whether there should be amendments to the existing laws. And finally, notwithstanding the first and the second, whether a specific and stand-alone act of parliament is required or is preferred. So to explore these 3 angles, we undertook 2 different phases. We call it phases. in our work. Phase 1 was the convening of a roundtable discussion. The aim of the RTD was to seek feedback, views and experiences from various participants on issues relating to cyberbullying. 67 participants from ministries, government agencies, professional bodies, universities and NGOs attended the RDT. They were from different disciplines. There were lawyers, there were civil servants, psychologists, criminologists and so on. So we had a very good representation of different disciplines. The findings of the RTD were summarized as follows. Number 1, cyberbullying must be criminalized. Number 2, definition of cyberbullying must be clear. Number 3, there is a need for a law against cyberbullying which must be drafted in such a way that it is relevant for at least 10 years. So this was phase 1. It was a face-to-face discussion, very robust and very interesting. Then we proceeded with phase 2. Phase 2 was the execution of surveys. We did this through the means of questionnaires conducted online. So 2 sets of questionnaires were formulated. A general questionnaire which was drafted for members of the public. This had the aim of eliciting feedback from public. The purpose was to discern the attitude, opinion and ideas Malaysians have towards cyberbullying. The questions drafted covered issues ranging from profiles to experiences of cyberbullying and action taken by the victims. The questionnaire also focused on the adequacy of laws and cyberbullying. Ladies and gentlemen, an overwhelming 89.3% were in favor of a standalone law. A separate questionnaire was designed for members of the legal profession, judiciary and those with legal backgrounds. We did this with the view that it needed to be more focused on law, and who better to know the law than lawyers, judges and those with legal backgrounds. You may think otherwise, but that is how it is. The premise was that since this focus of this research was an establishment of an anti-cyberbullying law for Malaysia, it was appropriate that the views of Malaysians with legal backgrounds, knowledge and expertise were obtained. So the questionnaires were distributed to judges, lawyers and academics. The questions drafted covered issues such as inter alia, the adequacy of existing laws. Each piece of legislation was dealt with separately. The experience in handling cyberbullying cases by lawyers and so forth. Again, ladies and gentlemen, an overwhelming 71.6% from the legal background, from the legal discipline, strongly agreed that standalone law was required to address cyberbullying. In short, ladies and gentlemen, there was an overall support for the establishment of a cyberbullying legislation to address this problem, right? So once we did the surveys, we got the numbers, we then continued with our work. So with the encouraging support motivating our work, we then embarked on the examination of our existing national laws and laws from other countries. I do not propose to go into details at the moment, as we are still in the research aspect of it, and also those issues are under debate and discussion. Suffice to say that we examined the relevant sections of the Penal Code of 1950. Penal Code of 1950 is Malaysia's law on crimes. As you can see, it was in 1950. India has got its IPC. IPC and our MPC have got very similar provisions because, as you know, we were under our colonial masters at that time. So in 1950s, 2022. So perhaps there should be revision of the Penal Code. However, going on, we also looked at the Communications and Multimedia Act of 1998. Now, the CMA of 1998 covers issues relating to cyberspace, internet usage, and so on and so forth, consumer protection, and other issues relating to internet connectivity and so forth, right? And also we looked at the Computer Crimes Act of 1997. Interestingly, there is a little story I would later share with you about something similar to Computer Crimes Act 1997 and the issue of cyberbullying. Anyway, whilst the aforementioned acts seemed appropriate, the question was whether they were adequate. So this was our national comparison of our national laws. Right? We studied the different laws that we had, and we looked at the sections, and we highlighted the strengths as well as the weaknesses. We then explored international legislation, and we looked at Singapore, Philippines, New Zealand, Australia, and the United Kingdom. Of particular importance or relevance to us, or I would say interest to us, was the Harmful Digital Communications Act 2015 from New Zealand and the Online Safety Act 2021 of Australia. Australia has amended its Online Safety Act. Oh no, Australia has come out with a new Online Safety Act 2021. Prior to this, they had Enhancing Online Safety Act, but now they have come up with a new act. I would leave this to our Australian expert to talk to us in detail. But why I said of particular interest, these two statutes were of particular interest to us. They focused on something that we, the research team, are emphasizing on. We are looking at the aspect of restorative justice, right? So we are looking at restorative justice. So what is restorative justice? This is a definition. Restorative justice, let me read it out to you. Restorative justice is a process that involves all parties affected by a crime participating in the process on how to deal with the offense and plan. This process involves victim-offender mediation, family group conference, and circle sentencing. Restorative justice requires both the perpetrators and victims to exchange information regarding incidents of bullying. The perpetrator is required to repair or to amend the harm as agreed by both the perpetrator and the victim, as well as to integrate the relationship of both. This makes the perpetrator directly responsible for the victim and at the same time to reduce the victim's fear. It encompasses both restorative process and restorative remedies. So this is what we are emphasizing on, right? So there are types and degrees of restorative justice practice. You have victim reparation, communities of care reconciliation, offender responsibility. So in where the victim is concerned, there will be victim support circles, victim services, crime compensation, victim restitution, victim offender mediation. Where the communities are concerned, it involves family services, it involves the family social workers, as well as local councils and so on, family groups. And the offender responsibility, where the offender is being held responsible, then you would have issues such as victim restitution, victim offender mediation, community conferencing, peace circles, family group conferencing, positive discipline, therapeutic communities, related community service, and so on and so forth. So this is what we want to achieve. We have been focusing, our laws focus more on penalties. We are penal centric. The laws that we have relating to crimes will have penalties of imprisonment, fine, caning, and so on. We are of the view that a more approachable solution, I would say, a more workable solution would be to adopt restorative justice, especially in areas of cyberbullying. The bully may be a minor, The victim may be a minor. The bully would not have realized what he did was bullying. So, in our view, it would be more relevant and more helpful if we had restorative justice process as well as restorative justice goals. The New Zealand model was in particular was useful to our work. Under the Harmful Digital Communications Act, an approved agency is created to deal with, amongst other things, cyberbullying. I call it the alternative dispute resolution mechanism, which is a mechanism other than a court of law, right? Again, studies have shown and interviews have shown people are very reluctant to go to the court of law. There is this mental block. Also, there are other issues involved as well, such as complexity of proceedings, the immense expense involved, all right, and also the I wouldn't use the word scary, but the dominating atmosphere of litigation. These have caused people to be wary of going to courts. So, for us, the approved agency from New Zealand, as well as the E-Safety Commissioner, Office of E-Safety Commissioner from Australia, can assist us in structuring our own mechanism, right? So, if you look at the functions of the approved agency, they are, and again, very wide, very flexible, to receive and assess complaints about harm caused to individuals by digital communications, to investigate complaints, to use advice, negotiation, mediation, and persuasion as appropriate. So, here you go, advice, negotiation, mediation, and persuasion. These are very attractive avenues of solving the problem. To provide, to establish and maintain relationships with domestic and foreign service providers, online content hosts, and agencies as appropriate to achieve the purpose of this act, to provide education and advice on policies for online safety and conduct of the internet. So, as you can see, they have very wide powers, right? They can also get the service providers and agencies involved. They can also, or they are also entrusted with the duty to provide education and advice on policies. So, these are in line with the aim of restorative justice. The powers of these ADR mechanisms are wide. They enjoy flexibility and are not bogged down with the rigidity of a court of law. Proceedings before them are not encumbered by formalities and complexities. Right. So, what are the challenges? When I am talking about the challenges, I would also speak about issues, all right. So, what are the challenges? So, the road to the sanctuary of a standalone law is not smooth. There are obstacles that we need to overcome and challenges that we have to face. First question, do we really need standalone law? Resistance to this stems from the view that existing laws are sufficient, that we do not need a separate law piece of legislation. To this, it is argued first, the laws are piecemeal. So, you have the Penal Code, you have the Communications and Multimedia Act, you have the Defamation Act, and so on and so forth. Under which law do we proceed? Secondly, they don't specifically cover cyberbullying, right? So, which law will apply? So, even if the amendments are better options, which law do you amend? Do you amend Penal Code, which is the primary piece of legislation on crimes, or do you amend the Communications and Multimedia Act? As it stands, both pieces of legislation are bulky and rather unwieldy. This is our view, right? So, where do you amend? How do you amend? Where will the amendments go? Again, it's a challenge. Secondly, all the main The main statutory acts of parliament that I have put forward to you carry penalties, right? They carry punishment. There are no there are no provisions for restorative justice. There is no such thing as bonding, community service, and so on. Of course, there are other laws that do have some references to restorative justice remedies, but these are not enough. For example, the Child Act 2001 has got some form of restorative justice solution. Unfortunately, it is also outdated, and the responsible ministry is looking into the review of the Act 21 years ago. Then you have the Sexual Offences Against Children Act of 1971, which provides counseling, but counseling here is for the victims. So it is very difficult for us to apply those principles here. We do feel that offenders as well need counseling. They need rehabilitation. So the proposed legislation that we are focusing on will focus on the restorative justice angle. For this, we derive inspiration from the HDCA as well as the Online Safety Act of 2021. Again, this afternoon's session, ladies and gentlemen, the forum discussion is very interesting because we have the privilege and the pleasure of having 3 renowned experts from Australia and New Zealand who have whose experience in the workings of these 2 mechanisms would definitely assist us and give us much to think about. Right. Secondly, definition of cyberbullying. Academics have come up with many definitions, and throughout our research, we discovered that the definition was not to our satisfaction. Right? So the issue that is debatable is the nature of the act committed. A key element that is common in most suggested definition is that the act should be repetitive. The Cyberbullying Act should be repetitive. We are of the view that whilst this adds to the severity of the offence, it should not be the deciding factor in concluding that the act concerned is cyberbullying. It could very well be a single act of cyberbullying could have brought more harm at the outset. So, in our view, it is debatable that whether the element of repetition should be included. The definition proposed by UNICEF is cyberbullying, and this is cyberbullying generally refers to the use of digital technology to post or send messages, pictures, or videos aimed at harassing, threatening, or targeting another person. So, for us, this definition is far more acceptable as it does not have the word repetitive in it. The research team, after looking at different definitions by academics and the law and the international instruments, have come out with our own. Again, this is still at the preliminary stage. It will be enhanced or fine-tuned after discussions with major parties. The definition of cyberbullying as we came out with is, cyberbullying means any act or series of acts committed by an individual or entity through digital communications or use of digital technology with the intent to cause harassment, alarm, distress, physical, psychological, economical, and or academic harm or other adverse effect to another person, otherwise known as a target person or victim, and as a result causing the said target person or victim harm, harassment, alarm, and or distress. Such intentional act includes, but not limited to, communication, posting, use, and or publication of threatening or abusive or insulting or offensive messages, videos, images, sharing personal or private information about a person without the authority and consent of such person with the intent to cause embarrassment, humiliation, or distress to that person, and any form of communications with similar intention. As you can see, our definitions are very wide, and We could very well fine tune it, but we have included the main elements that we are of the view are important to the definition of cyberbullying. We also will be looking at attempt to commit cyberbullying or aiding and abetting to commit act of cyberbullying. We call it the inchoate offences. So that is another angle that we would look at in greater detail. Then the next challenge, the scope, ambit and powers of the alternative dispute resolution mechanism. So we propose that the standalone law creates an independent alternative dispute resolution mechanism which will be given the powers and jurisdiction to address cyberbullying matters. I've already given to you an outline of those powers as set out in the HDCA, and I'm sure Brent and Ella would elucidate it further, enlighten us further with their experiences. However, the ambit and scope of the ADR mechanism as well as its enforcement powers need to be dealt with in detail. They should be entrusted with powers to grant interim orders, protection orders, notice to take down and so forth. At this point, the only remedy, you see, cyberbullying is an ongoing offense. There is recourse for the victim in the sense that he or she can go to the court of law to obtain injunction. However, there are problems because an injunction cannot be given independently. It has to be a remedy. It is a remedy that is based on a cause of action. So the victim must bring a cause of action against the perpetrator and in between then apply for injunction, number one. Number two, injunction is a special remedy, equitable remedy that can, or royal prerogative order that can only be given by the High Court. The High Court, ladies and gentlemen, is a superior court. So the cost will be expensive, to say the least. The victim has to get legal representation, and lawyers' fees are exorbitant, especially when you're applying for injunction. Number three, it is a complex application process. So it defeats the whole purpose of getting remedy for a target victim, getting justice for a target victim, because in this case, justice is expensive. Okay, right. So we will examine the powers that will be granted to the ADR mechanism when our proposal is accepted by our government, right? Then the hearing process and the procedures of cyberbullying cases in the ADR mechanism. How would hearing be carried out? What happens if either the victim or the offender or both are minors? Would there be legal representation? Would families be allowed to appear? In this regard, I think one of the examples we can obtain from our Malaysian legal framework system is the Consumer Tribunal under the Consumer Protection Act of 1994. Consumer Tribunal basically deals with complaints between the complainant, the consumer, and the manufacturer or the seller. So we have the view that we can obtain some lessons from the Consumer Tribunal. But once again, Consumer Tribunal is also a court of law. So although its proceedings are less complex, less formal, and certainly less expensive than a normal, ordinary court of law, it still has that aura of judicial proceedings, which may be daunting to victims as well as offenders. We will take the good, positive lessons provided by the Consumer Tribunal in suggesting our own blueprint, our own template for the alternative dispute resolution mechanism, right? Then the role of the police and the courts of law. So if we have the ADR, what happens to the court of law? What happens to the police? What happens to MCMC? All right, MCMC stands for Malaysian Communications and Multimedia Commission, which is a regulatory body of the telecommunications industry in Malaysia. They also have the powers to investigate complaints of cyberbullying. So what are the roles of these three organizations or entities when you have the ADR mechanism in place? This is something that we will look at. New Zealand has got this similar provisions relating to the role of the police and the courts of law. Again, at a conference or a workshop held by UNICEF a couple of years back, the young people, when told that the young people have to lodge a police report before proceeding with the complaint of cyberbullying, immediately shrank back in fear because, again, they found it daunting. So this is another challenge that we need to examine in detail. Awareness. This is something that, or lack of, this is something that we gathered from the surveys that we conducted, the ones that I referred to earlier, okay? And the feedback we got was that people did not know what to do. People did not know where to go. People did not know what they would do, what was being done was unlawful. They thought it was wrong, or they thought it was, it was just banter, of course, banter with the harmful effects. They did not basically know what to do. So this is another challenge for us. We would want to incorporate education into the legislation, right? So that would be the responsibility of schools, NGOs, and so on and so forth. Cybersecurity Malaysia has already a comprehensive awareness system for schools. What about public? Ladies and gentlemen, the one thing that I gathered from the research we were doing was that the focus was on children. Adults get cyberbullied too. Adults commit suicide as well. Just to show you a simple example, a 41-year-old firefighter in New York, a strong and bold woman, a young woman, strong and bold woman, right? She courageous. I mean, you have to be courageous to be a firefighter. You have to be fit and courageous to be a firefighter. She was cyberbullied by her own colleagues. Identities were not revealed. Again, that is a challenge for us, how do we identify cyberbullies? Identities were not revealed, but her body was found in her car by a riverbank with a suicide note, that she was driven to suicide as a result of cyberbullying. It applies to adults as well. The Korean actors I mentioned earlier, and you have many other examples, far too many. I could spend an hour or so highlighting suicide cases from all over the world. Okay, so cyberbullying applies to adults as well. So this is where awareness helps. Raising awareness amongst adults, children, having workshops, seminars, and so on, making it user-friendly so that people can address their problems and can seek solutions without having the burden of worrying about it. So this is where awareness comes in. And then the role of service providers. Both Australia and New Zealand, in their respective laws, cover the role and responsibilities of service providers. It is very difficult to monitor traffic, internet traffic. We all know that. And Malaysia has got a bill of guarantees that basically promises there won't be censorship of the internet. So to expect a service provider to censor issues or content in the internet is a bit too much. However, there should be some form of responsibility on them. The best analogy or example I could provide you is what we have under the Communications and Multimedia Act, the role of the ISPs. We have what is known as content code. This is a code that is created under the CMA that covers content in the internet. And under the code, the ISP is given an opportunity to defend itself. So instead of the ISP being automatically responsible for offensive content, they are given an opportunity to rectify the situation. Once a complaint of offensive content is given to them, they have to warn the account user or the subscriber and inform the subscriber to take down the offending material. If after 90 days or a certain number of days the subscriber did not take down the offending material, then the ISP would delete the account. So this is just one aspect of it, but hopefully we would be able to work with the ISPs to identify their responsibilities and duties. Certainly I know some of the telcos are very, very focused on cyberbullying and dealing with issues of cyberbullying. So it is something that, since it's a social menace, all of us are involved, regardless of what we do and where we come from. So those are the challenges. Again, there are logistics, there are research challenges and so on, but I've given you the core challenges that we at the research team, the research team of MMU will be dealing with. Right. Having done with the challenges, what are the recommendations that we are making? Right. Based on the interviews, opinions and research analysis obtained by the research team of MMU as detailed above, the foremost recommendation is that Malaysia establishes a separate standalone act of parliament to combat cyberbullying. Okay. The proposed standalone act should have a holistic approach and cover various issues. Holistic approach, so we are covering as many different issues as possible and as relevant to our work, right? And definitions, sanctions, both penal and non-penal, rehabilitation process for the offenders, interlocutory and or protective duty orders for the victims, and also balance the restorative justice principles. There should also be provisions that cover roles, duties and responsibilities of the service providers akin to the Communications and Multimedia Act of 1998. The UN Committee on the Rights of the Child has identified cyberbullying as a new form of mental violence against children and encourages state parties to take appropriate measures to prevent and respond to this issue. This provides support for a recommendation that we should have a specific piece of legislation that will address this issue. Malaysia is a state party to the Convention of the Rights of the Child, and under the law of treaties, it is obliged, Malaysia is obliged to incorporate its international obligations into national law. It is recommended that under the guise of these international obligations, Malaysia establishes a specific piece of legislation that addresses cyberbullying regardless of age. Then, the proposed Act of Parliament. The supreme law of Malaysia is the federal constitution, right? So whichever law that Parliament passes has to fit or has to be in conformity with the federal constitution. The proposed Act of Parliament would fall under Article 74, sub-Article 1 of the federal constitution. You see, in Malaysia, we have what is known as a federal law and state law, or federal legislation and state legislation. Each state in Malaysia has got jurisdiction to pass legislation that governs the citizens of that particular state, or that governs the running of that particular state. Parliament is authorized to enact any law so long as it is within the boundaries of List 1, which is known as the Federal List, and List 3, which is known as the concurrent list of the 9th schedule. The items that we identified are items 4A, B, and H of List 1 and item 1 of concurrent list. It is recommended that anti-cyberbullying law becomes a federal law throughout Malaysia. Cyberbullying is a national problem and not one peculiar to any given state. Leaving it to the respective states to legislate law against cyberbullying can be risky, as some states may decide either not to enact any law or delay the enactment of such a law. Therefore, a cyberbully who commits an offence in a state where it is not deemed illegal may escape prosecution. This will also defeat Malaysia's national cyber strategy and our obligations under international law. So our recommendation is that the proposed standalone law will become national law. Our fifth recommendation, Malaysia should consider the Online Safety Act 2021 and Harmful Digital Communications Act of 2015 respectively for the following reasons. Both these acts provide for the establishment of an alternative dispute resolution mechanism other than the court of law. These are the Office of E-Safety Commissioner in Australia and the approved agency called NetSafe in New Zealand. Proceedings are not formal, complex, expensive, or time consuming as proceedings before a court of law. Both these entities have wide discretion to receive, assess, and investigate complaints. So they do have the power to throw out complaints if these complaints are frivolous, trivial, or do not have any merit. They have the powers to use advice, negotiation, mediation, and persuasion to resolve complaints. They do endeavor to achieve a balance between the rights of the victims and the interests of the offenders. Ladies and gentlemen, before I end my keynote address, earlier on, this is a narration, a story if you like. The first time I came across cyberbullying, an act of cyberbullying that ended up in tragic consequences was when I was teaching cyber law to my students. And as I was doing my research, there was a particular case that came to my attention. This involved, I'm not sure whether it still is around today, but it was very popular a couple of decades ago, called MySpace. 14-year-old Megan Meyer, a shy, retiring teenager with insecurities, with normal teenage insecurities, registered herself in MySpace. MySpace had an age limit of 14. She was 13 at that time. She registered in MySpace and she started getting to know people in MySpace, in particular a boy called Josh. She became very friendly with Josh. Now this girl, like I said, she's insecure, she was shy, she had body weight issues, although frankly speaking there wasn't any problem, but you know, she had this misconception that she was fat and so on. And somehow this boy gave her the confidence and the independence that made her stand out, that made her happy. And this was her usual way of passing time every day. She'll come back to school. From school, she'll go up to her room and she'll be chatting with this boy. When she asked about details about this boy, he said that he was homeschooled, he doesn't go to schools, he studies at home, and therefore he does not have any friends. So they were, very friendly with each other, and she became to rely on him actually. Josh then started becoming nasty. He basically called her names. he said, you know, he knows that her classmates and her college mates are gossiping about her. She's not a nice person. And one very telling statement that he put, ladies and gentlemen, had very tragic consequences. "You are a waste of space," he said to her. Megan's mother said that she did bring it up with her, i.e. Megan did bring it up with the mother, and the mother stopped her from going to MySpace. Now, ladies and gentlemen, I'm sure as parents you will know that stopping your child from doing something is actually encouraging her or him to do it. So Megan carried on. Megan's mother had taken Megan's sister to the dentist. They came back home, the house was very quiet. Megan's mother went up to Megan's room, and there she found Megan hanging hanging in the closet. Megan had died. Police were called. They took away the computer to do forensic search, forensic evidence, to look for forensic evidence, and they discovered that she was chatting with this boy Josh. Now I'm going to use quote unquote this boy called Josh. So the police contacted MySpace, and MySpace revealed all the information, the IP address and so on. It was discovered, ladies and gentlemen, that Josh was not a real person. It was a fictitious identity created by, of all people, Megan's best friend's mother, a 41-year-old woman called Laurie Drew. Laurie Drew, shockingly, was also the best friend of Megan's mother. So they were all like within the same community, they were friends with each other. Laurie Drew was arrested and charged in court. At that point, at that time, there was no specific law against cyberbullying. The law used by the prosecutors in this case was the Computer Fraud and Abuse Act, which is similar to the Computer Crimes Act that we have. In fact, we have derived many issues from that particular act. Unfortunately, that crime did not fit into the provisions of the act, because those provisions talk about computer-related offenses such as hacking, cracking, phishing, and so on, unauthorized access, unauthorized modification, and so on, nothing to do with cyberbullying. As a result of that, the judge had to throw out the charges because he said that that particular act was not relevant to Megan Meyer's case. All right, so here we do have the Communications and Multimedia Act, ladies and gentlemen, but again, you can see what would happen if you do not have a specific law addressing the issue. All right, so Laurie Drew was acquitted. Story did not end there though. Again, this is the negative aspect of internet. People found out where she lived, and emails were sent out, and it was highlighted in social media, and people went to her house and threw eggs and harassed her, and so much so that she had to move out. And not only she moved out, she got separated from her husband as well. This is really nothing compared to what poor Megan went through. Subsequently, Michigan, the state of Michigan, passed the law, also known as the Megan Meyer law on cyberbullying, but unfortunately Megan Meyer could not be saved because there was no adequate law at that point. Right. Thank you very much for listening to me. I will now come to the conclusion of my speech. My team and I are fortified by the fact that MCCS states emphatically that the first order of Pillar 2 is to study and review all the existing laws and regulations that have been used to deal with cybercrime and cybersecurity cases. The strategy states that findings of said efforts will not only pave the way to appropriately update the existing legislation and regulation, but will also help to introduce a new law in cybersecurity if deemed necessary. It is the belief of our research team that the standalone law will provide a healthy digital environment for the citizens of Malaysia as envisioned by the MCCS. We are strong advocates of restorative justice and believe that the time has come for Malaysia to move away from the penal-centric approach that we inherited from our colonial masters towards a restorative justice approach that would achieve justice and a balance between the rights of the victim and punishment of the offenders. Our work is also in conformity with the United Nations Sustainable Development Goals. We also hope that we will set an example for other ASEAN countries. Ladies and gentlemen, thank you for your patience in listening to me. At this juncture, I would like to thank my wonderful research team who have been very supportive of our work from day one, going beyond their calls of duties to carry out our research work, and also in organizing and executing of this symposium, which was no easy task. At one point we had 12 participants registered and we were flipping hoping that we would get more than that, and as of today, this morning, we had more than 180. Thank you so much for sharing, for coming today and listening to me. I would like to thank our consultant, Puan Norasha binti Muyub, the rest of our team, Associate Professor Dr. Rahim Kamaluddin, Dr. Nora Azlin Fauzi, the chairman of the organizing committee, Dr. YYUN, Dr. Junaina, Puan Hamzatullah Zura Hamza, Miss Nur Shamimi Hood. I had a little bit of a mental block there. Sorry, Mimi. Ben Chia, and also the team at MMU Studio, as well as Faculty of Management, as well as our dear President for taking time off of his busy schedule. He is in Malacca at the moment. And other members of our Secretariat. Finally, my concluding remarks. I would like to quote Madam or Miss Marta Santos Pius, the UN Special Representative of the Secretary General on Violence Against Children. She said, preventing and addressing bullying will no doubt contribute to the promotion of the safe and non-violent learning environments and to elimination of physical, sexual, and emotional violence that the Sustainable Development Goals seek to guarantee. Ladies and gentlemen, thank you for your patience. I hope and I'm sure you will have a wonderful rest of the day. I'm looking forward to it. Now I can go and have my coffee. Back to you, Ben.
All right, thank you, Dr. Barma here, for the very insightful speech. I'd like to announce that we will be having a tea break and a networking session right now, and we will continue the session by 11:10 a.m. Thank you, everyone.